Today I want to talk about the legal environment for people with disabilities in the United States. When I teach education courses, one exam question I always ask is whether a free, appropriate public education is a constitutional right. Some future teachers always miss that question. There is nothing in the Constitution, the Bill of Rights, or any constitutional amendments about the right to a public education. In fact, it is less than 40 years since legislation has passed in this country that guaranteed education to all children, regardless of ability or disability. Before the passage of the three laws I am going to describe, children with physical or mental disabilities were excluded from the public schools. Parents either had to pay for private schools that specialized in educating them, place them in residential institutions, or care for them at home. There are many good books and films that can be used to understand the changes that have occurred because of the laws passed in this country between 1970 and now. One that I highly recommend is the feature film Music Within, based on the life of activist Richard Pimentel. Three key laws dealing with disabilities have been enacted by the United States Congress. The Individuals with Disabilities Education Act, usually referred to as IDEA, was passed in 1975. Like the Rehabilitation Act was passed in 1973, but did not become effective until 1977. The broadest reaching legislation is the American with Disabilities Act, referred to as ADA, which passed in 1990. These three pieces of legislation differ in who they cover. The IDEA only covers K-12 public schools, although there are provisions of the law dealing with services for preschool children. The Rehabilitation Act of 1973 forbids disability discrimination for those organizations that receive federal funds. The American with Disabilities Act forbids discrimination against individuals with disabilities in employment, public services, public accommodations, and telecommunications. The IDEA lists 13 areas of disability that are covered by law. It requires a free, appropriate public education for all students in the least restrictive environment. Schools must prepare IEPs for students with covered disabilities, and according to the 1997 amendments, schools must provide assistive technology if it is determined necessary by the IEP team. The Rehabilitation Act does not list specific disabilities, but uses the general description, persons with a physical or mental impairment which substantially limits one or more major life activities. There are two sections of the Rehabilitation Act that are often referred to, Sections 504 and 508. Some schools use Section 504 to provide supportive services for children who do not have a qualifying disability under IDEA. Section 504 students do not need an IEP. Section 508 refers to electronic and information technology, such as computers and telephones. ADA is the most far-reaching law. The authors of ADA were able to use experiences of individuals and organizations covered by IDEA and the Rehabilitation Act to assist them in drafting the legislation. Initial implementation of ADA has focused on physical barriers such as ramps, accessible bathrooms, and aisle width. We have explored how the schools have implemented the three laws that forbid disability discrimination. These changes have provided changed expectations for parents and children visiting the library. In addition, libraries need to determine whether they are meeting both the letter of the law and the spirit of the law in their services.